Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, ladies and gentlemen. Glad to see you all here. This special session of the court is to hear the case of Brown versus the United States. Is everybody ready? You may proceed. There is under that curious little device a button which raises and lowers the podium.
Yes, thank you, Your Honor.
Are you aware of it?
Yes.
Somebody briefed you.
Yes.
You may proceed, sir.
Thank you, Your Honor. May it please the court, my name is Richard Pascosen, and I represent the petitioner, Ms. Thursday Braun. I will show that the Commerce Clause does not authorize the theft of Major Artwork Act, and my co-counsel, Philip Zuchek, will show that if the act were constitutional, it would not apply to this case. May I reserve 2 minutes for rebuttal? This act does not regulate commerce, but instead criminalizes ordinary theft, which should be left to the states. This court should reverse the decision below for 2 reasons. First,
would you repeat what you said, that this act does what?
This act criminalizes ordinary theft, which should...
I thought theft was a crime in the first instance. Ordinary thievery is also a crime. It's just not a federal rap.
Correct, Your Honor. The federal government should not criminalize ordinary theft without any interstate implications under its Commerce Clause power.
But it can't under this statute because it applies only if the institution from which the theft is made is one the activities of which affect interstate or foreign commerce.
Yes, Your Honor, the institution is required to affect interstate or foreign commerce, but under our Commerce Clause jurisprudence, the activity itself must be an economic activity with an effect on interstate commerce.
But this is a certain kind of theft, not a theft of anything. It's theft of our cultural artifacts.
Yes, Your Honor, but there is not a sufficient limitation if this court allows Congress to regulate the theft of objects of cultural heritage by finding that this theft is some sort of economic activity with a substantial impact on interstate commerce.
But I want to go back to the museum because the statute applies only if the theft comes from a museum. That's the theft of a certain sort of thing, too. Do you think museums buy insurance for theft?
In some instances, yes, museums insure their artwork against theft.
In some instances?
Yes, Your Honor. There is no definitive proof that all museums, or even most museums, insure all of their artwork.
So some might self-insure. I accept that. Although apparently it's about a $6 billion a year business to steal things from museums.
Yes, Your Honor. This speaks to the economic nature. I will show that the theft as it is written in this act is not an economic activity with a substantial impact, as well as museums not being instrumentalities under the Commerce Clause. Under this first point, the activity of theft is not an economic activity.
I thought it was an economic crime, actually.
Your Honor, it is a crime, but it is not economic as the court has defined it in the seminal case of Gonzalez versus Raich, which considered the application of the Controlled Substances Act. The court there defined economic activities as things regarding the production, distribution, and consumption of commodities.
But I'm going in a different direction than Gonzalez. That's, of course, about the marijuana. Theft, in the grand scheme of crimes, is an economic crime. It's not a crime of violence. It's not a crime dealing with status or anything. It's a crime that involves taking something of value from another, right?
Yes, Your Honor, it does involve taking, but that does not make it an inherently economic crime. Like any other crime considered by this court, it involves simply a victim and a perpetrator. It is a traditional state criminal activity of the sort that should not be regulated under Commerce Clause authority.
Isn't there a national problem with the theft of this kind of artifact? I mean, if you isolate it to the one little thing, you have a point. But if you take it in the aggregate, with the worldwide problem of stealing of this kind of thing, why doesn't that have an impact on the economic system?
Your Honor, there is indeed an illicit market for objects of cultural heritage, but theft is not necessarily the only mechanism by which these objects move in an interstate market. In fact, Congress has regulated in other areas to prevent the formation, or at least reduce the formation of this illicit market through other acts in Title 18 of the U.S. Code prohibiting things such as embezzling these objects or trafficking in these stolen objects and other similar objects of cultural heritage.
But why is Congress limited to those areas? Doesn't Congress have broad power, and don't we need to assess this statute with that in mind?
Yes, Your Honor. Congress has broad, but still enumerated powers. And
This case strikes me as nothing like Lopez or Morrison. Those cases involve, respectively, possessing a gun near a school or committing violent acts, and I can certainly see that beating up somebody isn't economic, but taking their car from them, taking artwork.
What's the basis on which you're drawing a distinction between embezzlement and theft in terms of the Commerce Clause?
Your Honor, embezzlement involves the moving of a commodity through commerce. It involves movement from one person's implied possession of it into another market. Theft does not necessarily regard this, because theft may be done for any number of reasons, even if it has some tendency to move things into an interstate market. Theft by itself is not an economic activity.
Don't we look at the effect on interstate commerce?
The effect on interstate commerce can only be evaluated in the aggregate if the activity itself is economic, as the activity in Gonzalez versus Raich was. When the activity is not economic, such as the battery of women considered in United States versus Morrison, the aggregate impact becomes irrelevant, because any sort of arguments put forward become costs of crime arguments, that the generalized impact of these crimes affects interstate commerce in some broad and almost indefinable way. This sort of indeterminate effect is exactly the sort of attenuated connections that were disallowed in these acts, and the connections put forth by the government in its arguments below. The connection...
Would you argue that a statute prohibiting theft of endangered species of pelts, or a statute prohibiting theft from the Smithsonian Museum, or a statute prohibiting any other type of theft is also unconstitutional?
No, Your Honor. The Act would have to specifically make sure to regard specifically the channels or instrumentalities of interstate commerce, as other acts such as the National Stolen Property Act do, by requiring that these objects themselves have moved in commerce.
But if you asking us to overrule the third prong of Lopez?
No, Your Honor. The third prong is still alive and well, as seen in Gonzalez versus Raich. And Congress may regulate economic activities with a substantial impact on interstate commerce. But where the activity is not economic, where the impacts are attenuated at best, and where Congress has not evidenced that it has a rational basis through any sort of legislative findings or history that they consider this act to regard the interstate commerce, then this court should not allow such an act to stand under Commerce Clause authority.
I thought, though, there was some legislative history to suggest that Congress saw a problem here in terms of the impact on this kind of theft. Am I wrong?
Yes, Your Honor. The legislative history put forth in the record below on page 9 did not actually regard the Theft of Major Artwork Act, but instead regarded a distinct act put forth by Senator Kennedy immediately following the theft of several high-profile items from the Isabel Stewart Gardner Museum. This act was proposed because Isabel Stewart Gardner was a close friend of Senator Kennedy, and he sought to react to this by providing some sort of federal protection. This act did not pass the floor in Congress in 1991. And the Theft of Major Artwork Act, as enacted in 1994, was significantly different, and the legislative history from that prior session should not be regarded as evidence that Congress considered the economic impacts of this act.
In specific reference to this statute. So you're
Yes,
saying
Your Honor.
they've addressed the problem, but not in specific reference to this statute.
And at a different time and place and in a different manner. Yes, Your Honor.
It seems to me that you're asking us to consider the theft of these items in isolation. But if we consider it in the aggregate, don't we look to the aggregate for the impact on interstate commerce and so?
No, Your Honor. The aggregation test put forth in Wickard v. Filburn and applied again in Gonzalez v. Raich once again only reaches economic activities with a substantial impact on interstate commerce, where the activity itself regards the production of commodities as the production of marijuana clearly does. That activity may be aggregated and the local...
What about the growth of wheat in Miller's building?
Similarly there, that is the production...
Local?
Yes, Your Honor. It was local, but it was the production of a fungible commodity, and therefore the aggregate impact of producing this commodity could be considered in its effect on interstate commerce.
What about car theft?
Car theft may be acceptable under a different prong of Commerce Clause legislation, such as the channels, regulation of car theft, I'm sorry, Your Honor, may be acceptable under the channels and instrumentalities of interstate commerce.
Why? Why does it have to be there? Suppose they just put it in the back of a carrier or something like the tow trucks are now, so the car isn't driving itself, somebody's just stolen it.
Yes, Your Honor, but this would involve an actual instrumentality of interstate commerce, something that works to move things across state lines. This court found in United States v. Cobb that things such as planes, trains, and automobiles are instrumentalities of commerce because they move goods across state lines in the aggregate. Which turns me to my second point, that museums are not instrumentalities of commerce because they do not serve to substantially facilitate the flow of interstate commerce into an area.
They don't? How much business do museums attract to cities? So, for example, in the city of Chicago, the Art Institute of Chicago brings countless visitors from all over the world and is quite a boom to the local economy.
Well, they come here, we count them anyway.
Yes, Your Honor. And such an institution is clearly an instrumentality of commerce in that particular instance. However, the Act defines museums extremely broadly as including anything which affects any permanent organized institution which affects commerce and additionally meets these minor requirements of being a museum. This includes cases that clearly are not instrumentalities of commerce.
But that doesn't speak to Congress's power to pass law. It just speaks to whether in any given case the proof of interstate commerce effects has been satisfied.
No, Your Honor. It does matter that the language used by Congress is too broad to only be applied to instrumentalities of commerce because if Congress is regulating these instrumentalities, it must do so in a consistent way through things such as a specific enough jurisdictional hook that ensures that only those institutions which substantially facilitate interstate commerce in an area are reached by such an act.
Do you think Congress has the power to regulate price fixing?
In some instances, yes, Your Honor, especially because it regards economic activities in most instances.
Right, but that's basically theft from consumers.
No, Your Honor, it is regulating the economic transactions that consumers participate in. By regulating such a thing as price fixing, this regards the economic activities prong in a more substantial way. Thank you, Your Honors.
Counsel?
May it please the court, my name is Philip Zuchek and I represent the petitioner. Your Honors, this act applying this act to purely private collections would do a disservice to our nation's museums burdened by the recent proliferation of art theft. This court should reverse the decision below for 2 reasons. First, the Galisteo Foundation is not a museum as defined by the act. And second, the 3 stolen objects were all under the care, custody, or control of a private individual. Turning to my first point, the Galisteo Foundation does not satisfy the requisite elements of a museum as defined by this act.
Why not? It has visitors come from all over the country to see things in the place. Why is that a museum?
The evidence in the record alone of some in and out of state visitors that have traveled to this particular institution, in this case, is not sufficient to show an effect on interstate commerce. Had there been any further evaluation of this effect or the
Well, if the museum were closed, they probably wouldn't have gone to the museum. That has an effect on interstate commerce, doesn't it?
By the museum being open alone, that is not an effect on interstate commerce as contemplated in this case. An effect on interstate commerce is typically derived from some sort of facilitation of interstate commerce, or the facilitation of flow of goods or individuals.
Well, it purchased things in the construction from interstate commerce, did it not?
Yes, Your Honor, it did. However, those purchases were on a one-time basis, and the services that they procured were also on a one-time basis. Therefore, the record indicates that the Galisteo Foundation has received some in and out-of-state visitors, and
in keeping with my colleague's question, I think that's quite significant. This court's case in Summit Health against Pincus suggests that a very low level of economic activity is enough. Something on the order of $50,000, a year was found to be enough there, and the court wasn't really interested in the business of counting pennies.
Yes, Your Honor. However, in similar cases decided by this court, such as Katzenbach versus McClung, this court has looked at the actual facilitation of the tourism and travel trade, and whether or not that facilitation showed an actual effect on interstate commerce.
But the record we have here tells us that visitors, both in-state and out-of-state, come not only to see the house, but also to view Smith's extensive private collection, some of which is on display in the house.
Correct, Your Honor. However, the individuals that do come to see this exhibit not only are, as will be provided in my second point, not only are the objects in Mr. Smith's private collection his own personal private objects, but there is no additional information as to the amount or even the frequency of these individuals traveling.
Isn't it very common in art museums to see things on display with a little tag that says, this is being shown through the generosity of Mr. and Mrs. Smith, or they'll borrow and put together a particular show?
Correct, Your Honor. That does typically occur.
And so why is that what happened here any different? Just because Smith happened to own it, the museum was showing it.
No, Your Honor. It's not merely that Mr. Smith owned these objects. It's also the fact that he used the Galisteo Foundation, the Galisteo House, as his own private residence. This is not merely a museum as contemplated within the Act, but did serve this dual purpose of his private residence.
So if it was in the care and custody of him as well as the museum, that would still come within the definition of under the Act, wouldn't it? I mean, it doesn't have to be exclusively in their care and custody. It doesn't say that.
That is correct, Your Honor. However, there is no indication that the Galisteo Foundation did have care, custody, or control of these items. This speaks to my second point that the Galisteo Foundation, or rather that the 3 stolen objects were under the care, custody, or control of Mr. Smith exclusively.
He wasn't even there half the time, much of the time, correct?
Correct, Your Honor. However, he did not take the care to transfer any sort of responsibility to the Galisteo Foundation for the objects of his private collection.
Is that consistent with the record? Apparently, with one exception, the objects that were stolen were kept in areas of the house that were accessible to the public. In other words, the museum-ish areas of the house.
Correct, Your Honor. However, those objects were still under the part of the personal collection of Mr. Smith, and he was allowed to do with these objects as he pleased. The Galisteo Foundation had no responsibility over these objects, and Mr. Smith very well could have gone up and grabbed any of these objects.
Going back to Justice Wood's point, somebody who lent a piece of art to a museum could come back and say, no, I want that Van Gogh back. I need it back in my living room, right? I mean, that could always happen.
Yes, Your Honor, they could. However, in that case, a conversation occurs, and there is some sort of explicit transfer of responsibility. This individual will walk into a museum with their particular painting and either say, I donate this or I give this to the care of the museum, and if they return, they would have to have that same sort of conversation. The conversation does not exist here because Mr. Smith was the sole owner of these objects and the sole person with care, custody, and control.
But they were mixed in with other objects that the museum did own.
No, Your Honor.
Didn't the museum control access to this building? And didn't they guard the objects in the building?
Yes and no, Your Honor. The Galisteo Foundation did own the tangible object of the house, and they did control the ingress and egress.
And own the whole building.
Correct. However, none of these additional objects displayed were owned by the Galisteo Foundation. Mr. Smith merely transferred the ownership of the Galisteo house to the Galisteo Foundation, but even then still decided to use this as his own private residence.
But why does that prevent us from meeting the criteria in subsection B of the statute that Mr. Smith's items were in the care, custody, or control of the foundation? It doesn't say owned by, it says in the care, custody, or control.
Correct, Your Honor. And there's no additional assistance as to what care, custody, or control in this case mean. And therefore, looking at a plain meaning approach of these terms, you can see the broad span of possessory influences that can fall under care, custody, or control.
How about just common sense that he entrusts the museum to show some of his collection, some of it's in storage? That's a very common notion as well.
Yes, Your Honor. He does. These objects are under the display in the museum. However, there needs to be something more than merely placing these objects on the wall and still owning them as their own, as Mr. Smith's private objects.
What case do you rely on for that proposition?
Your Honor, that's under the plain meaning approach of care, custody.
What case do you rely on to support your proposition?
In general, museums take particular precautions to ensure that there is an actual transfer of care, custody, or control.
Are we getting zoo check on care, custody, control?
No.
Is there some authority that you can cite to us that we should rely on?
Yes, Your Honor. In a Fifth Circuit case, United States versus McLean, the Fifth Circuit specifically looked at the application of the National Stolen Property Act. However, in that case, also evidenced that museums painstakingly take these measures to ensure that there is actual documentation and transfer of responsibility in most cases.
What's the purpose of those measures?
The purpose of those measures is to ensure that there is actual knowledge of who is responsible for these objects. And because in this case there is no way of distinguishing clearly who had responsibility over these objects, the care remains within Mr. Smith personally as his private objects.
Well, I don't think you've answered Justice Mikva's question about why this can't be some form of at least joint control. He's not, as she points out, he's not even there most of the time.
Correct, but under the plain meaning approach of control, there would have to be some sort of actual physical dominion over the object, which the Galisteo Foundation did not exercise in this case.
How about custody is located there?
Yes, Your Honor. However, custody still connotes some sort of duty to care for these objects. And the particular employees of the Galisteo Foundation or the foundation itself were not responsible for the objects of Mr. Smith's private collection.
Is there somebody for the foundation there 24 hours a day, 7 days a week?
No, Your Honor.
So that sometimes they were there without himself, and other times he was there without anybody from the foundation?
Correct. The two employees that were actually employed by the Galisteo Foundation were the part-time property manager and the part-time gardener. However, of these two, only one person was entrusted with the minimal task of providing tours of the Galisteo house. but that does not entrust responsibility over Mr. Smith's private objects.
The people who were on the tours see any of Smith's objects?
Yes, Your Honor.
Well, why isn't that part of the museum's control?
Because
They bring people there to look at it. Why isn't that controlled?
Because the museum actually had there was nothing additional to show that the responsibility was handed to the museum in this case. The museum, in fact, had no way of knowing what objects they were responsible for and what objects they were not.
I don't see what that has to do with whether this is a federal crime. It certainly might mean that the museum is being managed in a sloppy way. But if it meets the definition of the museum, that is to say there are these objects in care custody, but it meets the first definition. And then secondly, someone takes one of the objects that people are viewing on, could be viewing on the tours or are, something from the public areas especially, that would make it a federal crime. The federal government isn't trying to protect museums from poor management.
Could you rephrase
Well,
your question?
we were stressing the fact that the museum may not know what's exactly there, and that maybe they haven't kept a proper inventory, or maybe they could have better security, but I don't see what that has to do with meeting the statutory requirements of 18 U.S.C. section 668.
Your Honor, there needs to be a fine line distinguishing what actually is under the care, custody, or control of a museum and what isn't. If a broad variety of influences were found to be under the care, custody, or control of a museum, then any individual walking into that museum with an object of cultural heritage might fall under protection of this act, and that would not be the intention in this case. This act is intended to protect museums and not individuals, private individuals, that own objects of cultural heritage. As stated previously by my co-counsel, that was particularly rejected in the case of the Gardner theft. There is no indication that Congress attempts to protect private individuals from private theft. However, in these cases, the Galisteo Foundation would, excuse me, Your Honor, the federal crime, the issue with the federal crime would be that it could be over-applied to a variety of individuals and a variety of objects that could be under this very broad definition of care, custody, and control. By narrowing the definition of care, custody, and control, this court is actually able to see the responsibilities of these objects and prevent this act from being over-applied.
Narrowing to what? How narrow do you think it should be? What are you saying it means, other than ownership, which it clearly doesn't mean?
There needs to be something more. Anything.
From what?
An actual, even a conversation, or the easiest thing in this case would have been a contract. Mr. Smith was able to contract out the Galisteo house and handed it over to the Galisteo Foundation.
Well, they own the house. They don't own the objects, and the statute clearly distinguishes between ownership and care, custody, and control, because elsewhere it uses the word ownership. So there's clearly a decision not to say ownership.
Correct.
So what do you think we should say care, custody, and control means, if not ownership?
Care, custody, and control should connote an actual responsibility for objects that the institution was aware of at the time. One of these objects, particularly the Denisa letter, the foundation did not even need to know, or may not have even known that particular object was in the closet.
Okay, but so what? I mean, if there's one object, that's not going to get your client's conviction reversed, right? If she doesn't need to steal 5 objects to be guilty, right? Just one.
Correct, Your Honor.
Okay.
So are you conceding that there is a narrower application of this statute that would be unobjectionable, and that it's just potentially some instances it might be too broad?
No, Your Honor. Merely by looking at and interpreting the statute in the way, this court could avoid the constitutional question altogether by the canon of constitutional avoidance.
I thought you just agreed with Justice Mikva that, in fact, the theft of the objects that were in the areas accessible to the public, at least, is something that meets whatever test it is you're articulating.
No, Your Honor. I did not mean to say that. What I meant to say is that the Denisa letter specifically shows that there was no knowledge of the existence.
We're talking about the other objects,
yes,
not the Denisa letter.
Those other objects were still Mr. Smith's private collection, and he could have changed those objects on display at any given time.
So if I walk into the Art Institute tomorrow and pull something off the wall that says, through the generosity of Mr. and Mrs. Smith, you think I can't be pursued under this statute criminally?
Oh, certainly you could, Your Honor. However, in that case, particularly the Art Institute in that case would be found as an instrumentality of commerce and a museum, and they would have care, custody, or control of those items because of particularly the case evaluated in the United States versus McLean. These large museums voluntarily undertake to, I see that I'm running out of time. May I please answer the question?
Finish the question.
These large institutions, such as even the Field Museum, voluntarily undertake that whenever that they take on objects, that they be included with a specific pedigree of ownership in order to make sure that these objects were clearly under their care, custody, or control.
Thank you.
Thank you, Your Honors.
Counsel? You may proceed.
May it please the court. My name is Adriana Lopez, and I, along with my co-counsel, Joel Glover, represent the respondent in this case, the United States of America. We are asking this court to affirm the well-reasoned decision of the United States Court of Appeals for the 12th Circuit, which upheld the Theft of Major Artwork Act as constitutional and affirmed petitioner's conviction. In my co-counsel's time before the court, he will explain the statutory interpretation issue. And in my time before the court, I will explain the constitutional issue and show how the Theft of Major Artwork Act fits squarely within Congress's power under the Commerce Clause for two reasons. First, because a rational basis exists to find that the theft amount in the aggregate substantially affects interstate commerce.
Now, your adversary said that it's not necessarily aggregated. There still has to be an economic activity for each item in the act. Agree with that?
I don't, Your Honor. And the reason is because in United States versus Lopez, this court specifically declined to make a bright line rule that the aggregate impact test could only be applied to economic activity. Moreover, because in Gonzalez versus Rage, this court ruled that if an activity, a wholly interstate activity, non-economic, was part of a larger regulatory scheme that Congress had in place, that Congress could regulate that activity. And like Your Honor said, that case dealt with the homegrown marijuana that was used for medicinal purposes, not for sale, not for purchase. And this court ruled that that activity still could be regulated by Congress. And that's
Doesn't there need to be some kind of link? I mean, the definition of museum calls for it to be something whose activities affect interstate commerce. But, you know, suppose the director of the museum had some valuable antique necklace that was in her drawer, and somebody came and stole it. I don't see why, under your definition, that wouldn't fall under this statute, and it just doesn't seem to have anything to do with interstate commerce to me.
Your Honor, art theft from museums has intimate connections to interstate commerce in that.
But doesn't the link need to be there? The Galisteo House is interesting in the foundation. The thing that makes it even a museum is that it has this link to a famous architect. And that doesn't seem to have anything to do with this particular theft. And I'm just wondering how random it can get before you will give up on the applicability of the statute.
Well, Your Honor, when courts have looked to see whether or not nonprofits like the Galisteo Foundation could constitutionally come under the protection of the Commerce Clause, they look at various factors to see whether there is a connection between the nonprofit's activities and interstate commerce. For example, in United States versus Grassi, the federal arson statute was in question there, and the defendant had burned down a church. And so the issue was whether or not that church's activities in connection to interstate commerce was strong enough to merit its coming under the protection of the Commerce Clause. And the court held that it did, following this court's reasoning and precedent. This was the 10th Circuit. And
So what would be the fate of a statute that said a museum is an forbids people from carrying guns near museums because lots of children go visit museums and it might be seen to be dangerous.
Your Honor, if I'm understanding your question correctly, you're making a parallel between this statute and perhaps what was ruled as unconstitutional in the United States versus Lopez?
Right, where there was no jurisdictional element, and the difference would be this is one where the museum has to have activities that affect interstate or foreign commerce. Would you uphold that statute?
Just because of the jurisdictional element?
I'm just asking, would you uphold it? This is a constitutional application of Congress's. In other words, can they throw that jurisdictional element into just about anything and then essentially have a general federal criminal code?
No, Your Honor, they cannot. And in United States versus Lopez, this court specifically said that
You're fascinated with the name of that case, I'm sure.
no relation, I promise. This court specifically said that Congress just can't say it to make it so, and that this court still has the duty at the end of the day to decide whether or not Congress had a rational basis for its findings. And in
I'm
this,
not quite sure that's what Lopez said. There wasn't the same kind of jurisdictional element. If you're familiar with the statutes that make it a federal crime to be a felon in possession of a firearm, the only thing you have to show is that once upon a time, the firearm moved from one state or a different country into the state in question.
Correct.
That's pretty thin. So should we overrule those cases?
no, Your Honor, you shouldn't overrule those cases. But under this statute, this court must merely find that Congress had a rational basis for finding that art theft substantially affects interstate commerce. And this court gives great deference to Congress in that regard. And Congress has shown in the congressional record and otherwise that the theft of art is intimately linked to organized crime, affects supply and demand on a worldwide basis, increases the cost of art insurance, and is even a conduit for tax fraud.
So what if Bill Gates, as he may, has a fabulous private art collection? Do you think it would be constitutional for Congress to pass a statute that criminalized theft from private holders?
I guess it would depend, Your Honor. My inclination is to say no. However, what we have before us today,
The argument you just made would lead to a yes, because it would feed the interstate and international market and stolen artworks. Seems to me almost every evil you just described would follow.
well, if we look at Gonzalez versus Rage and take that as a kind of to draw a parallel, then private owners of these artifacts and cultural heritage items and great artworks perhaps may be able to come under the protection of the Constitution in that regard, because in Gonzalez versus Rage, this court did hold that even activities that individuals were engaged in that were not economic in nature could still be regulated. If
Well, in this statute, Congress relied both on the fact that we're talking about objects of cultural heritage and we're talking about the museum, both of which link it back to interstate commerce, isn't that right? I mean,
That's
we've
right.
got both things going on here.
That's right. Under
And
both.
in Justice Wood's example, only one of those things which may or may not be enough.
Well, one of those things would be enough, Your Honor, because under this court's three-pronged areas of activity in United States versus Lopez, if the museum is
An
an
instrumentality,
instrumentality,
Right.
then Congress would have.
which this museum may not be.
We would disagree, Your Honor.
Okay.
And
Can I have a question about this statute? What about the fact that the statute defines object of cultural heritage as any object that's worth over $100,000, which may be something that has absolutely no historical value or just anything that happens to be in the care, custody, or control of the museum? Where's the link to interstate commerce there?
because it would still be a major artwork, and because art theft is so connected to organized crime,
Where is there a limitation that has to be art?
So what if it's Mr. Smith's Lamborghini? It's an object, I think they're worth more than $100,000.
I don't know.
Let's just say
statutory language and the requirements there to answer your question more fully. But in United States versus Perez, this court said that organized crime is inherently interstate and international, and linked loan sharking, even wholly interstate loan sharking, to organized crime. And the same is true here. The congressional record that Senator Kennedy attached to this act, we see straight from the source, from FBI agents, U.S. Customs agents who have 20 plus years in the field working every day tracking down these heartbeats. And they tell us that, to quote one U.S. Customs agent, that drug kingpins use art the same way that they use gold or diamonds. They put their money into the art so then they can more easily smuggle it across borders.
Couldn't you get them under a money laundering statute? It seems like that's an indirect use, and part of our question here is whether the interstate commerce connections are direct enough.
Your Honor, the direct or indirect tests have been overruled by this court. This court no longer follows the direct or indirect test and uses the three prongs of Lopez. So if there is a rational basis for Congress to find that the theft of art in the aggregate substantially affects interstate commerce, then they have the power under the Constitution to do so.
But some of these old tests rear their heads in other guises, and the third part of Lopez does require a substantial relation to interstate commerce. And I would imagine that that means that if it's the house that Jack built, if it's step 1 leading to step 2, leading to step 3, leading to step 35, you would come to a point where there was no longer a substantial relation.
Your Honor, this court must merely find that Congress had a rational basis for its finding, and the Constitution entrusts Congress to make these policy choices. And
well, in your view, it seems to me you don't need a museum at all. If I have an artifact in my house and somebody comes in and steals it, would that be a federal crime?
it could be, Your Honor. At this time, my co-counsel might be able to talk more to the statutory language and what would apply, what wouldn't.
I'm talking about the Commerce Clause. Under the Commerce Clause, could Congress make that a crime?
If they found it and showed that they had a rational basis, in other words, some kind of evidence to show that that activity, if repeated elsewhere across the U.S. under this court's test, first set forth in Rickard versus Fulbright, if Congress had a rational basis to find that that activity would substantially affect interstate commerce if repeated, then yes, constitutionally, it would fit within the third prong of Lopez. And this, turning to my second point, museums like the Galisteo Foundation are instrumentalities of interstate commerce under the second prong of Lopez.
Do we need more evidence in the record other than just this sort of vague indicator that people are coming once a month to one weekend a month to this museum? Is that enough to put over the line to be an instrumentality?
That alone perhaps isn't enough, but when you take into consideration all of the different aspects of what's going on here with the Galisteo Foundation, it does. And those are the fact that it offers a broad range of educational and community activities to the local community, and in addition attracts out-of-state visitors, as seen on page 4 of the record. And when courts look to see whether museums like or nonprofits like the Galisteo Foundation can come under the protection of the Commerce Clause, they looked at the variety of activities offered, and so it's taking into consideration the whole picture, not just one or two factors. And so the Galisteo Foundation does rise to the level of an instrumentality of interstate commerce when it facilitates a flow of people, of money, of travel. People come to the Galisteo Foundation from other states. And in addition, Your Honor, the holding in Gonzalez versus Raich would also come into play here in that regardless of how big the museum is or how small the museum is, that even if it's the Met versus the Getty versus the Galisteo Foundation, that still regulating that activity and the crimes against those nonprofits that do affect interstate commerce could still come under Congress's power under the Commerce Clause, because it's part of a larger regulatory scheme of trying to combat this interstate and international trafficking of illicit art, of stolen art, which is a global problem. And it is the nation that can speak for all 50 states to combat this global problem in a uniform way that the states individually cannot. And the federal government has the resources to deal with this problem, the FBI resources, communication lines with other nations in the world. And so because a rational basis exists for Congress to have found that art theft substantially affects interstate commerce, and because museums like the Galisteo Foundation are instrumentalities of interstate commerce.
So we have to find, among other things, that Congress had a rational basis for what it did?
Yes, Your Honor.
You give us a real burden. You don't have it for everything they do.
So your argument is that it meets both the second and the third prong of Lopez?
That's correct, Your Honor. I see that my time's up.
Okay.
Thank you very much. Mr. Bauer, am I mispronouncing your name?
No, Your Honor, you're correct. May it please the Court. My name is Joel Glover, and I too represent the respondent in this case, the United States of America. In my time before the Court, I will explain how the Denisa letter, the Wales II scrimshaw, and the Carlton map fell under the intended protection of the Theft of Major Artwork Act for two reasons. First, because the three items were under the care, custody, or control of the Galisteo Foundation at the time of their theft.
Even the letter that he kept in the closet?
Yes, Your Honor, even the letter that was... Excuse me, Your Honor? Oh, Your Honor, it's the care, custody, or control extends to all items of cultural heritage within a museum. The protection extends to all items of cultural heritage, even though they're not on display. The Art Institute of Chicago, as Your Honor mentioned, holds over 250,000 pieces, and it's impractical to imagine that they could all be displayed at one time. However,
isn't there some knowledge requirement, though? Suppose somebody came into the museum and inadvertently left behind something that meets this definition of over 100 years old and worth more than $50,000. My example of a necklace.
It only has to be worth $5,000.
Oh, sorry, yes, $5,000. Sorry. So easy, necklace worth $5,000.
We all have doubts.
That's right.
I don't.
And so it's left there. The museum has no idea it's there. It's in the locker room or something. And now it's stolen. Is that a federal offense under this statute?
under this statute, Your Honor, respectfully, I would say no. The items...
So where are you getting the knowledge? I think that feeds back. So you're going to agree then that there's knowledge requirement. You have to know you have the thing before it's in your care, custody, and control.
Your Honor, the question is the object of cultural heritage?
Oh, care, custody, and control.
Of the knowledge of the care, custody, or
Right.
How do you care and custody without knowledge?
Right. Isn't it a prerequisite to being said that this was in your care, custody, or control, that you actually knew the thing was in there?
For the museum to have care, custody, or control, there must be knowledge.
Right. That's what I'm asking.
Yes, Your Honor. Although affirmative action, as in here, knowing that the object was under the care, custody, or control of the museum, is apparent in the terms of the Galisteo Foundation. But in general, if an incidental...
What do you mean by apparent?
If in the Galisteo Foundation, as Your Honor mentioned, the property manager that guided the in and out of state visitors around the Galisteo Foundation took the visitors, guided through there, and showed them the objects that were displayed, saved the Denisa letter. However, that was the custody, the affirmative action that was the custody of the objects in the Galisteo house. Here, a museum still has care, custody, or control of objects, even in storage, as discussed with the Art Institute of Chicago, or with the stored Denisa letter here at the Galisteo Foundation. However,
it's a little nice to call it a stored letter. It's in the closed closet.
I store all my stuff in the closet. They don't teach me.
yes, Your Honor.
No, but my serious concern here is that it really seems that you're blending together Mr. Smith on the one hand and the Galisteo Foundation on the other hand. And I'm concerned that this attribution may be going further than the statute
Respectfully, Your Honor, I would disagree that the Maxwell Smith's personal objects and the objects displayed within the Galisteo Foundation are akin to the hypothetical that you offered, leaving the necklace within the care, custody, or control of the museum. I would agree that a necklace left within a museum is not under the care, custody, or control of that museum. It's easy to look at the practical implications of visitors who come in and out of state, as the record indicates in this instance, to visit not only the house, but the objects displayed within the house. It's easier to make the link that those objects are under the care, custody, or control of the Galisteo Foundation. However, they're not drawn. The individual with the necklace who came and left it perhaps in the bathroom is not the one who, there's not the same link to assume that the care, custody, or control extends to those objects within the museum.
Okay, so fair enough. So is there anything whatsoever that Mr. Smith owns that is over 100 years old and worth in excess of $5,000 or worth at least $100,000 that is not attributed to the museum, is not something that would be within this statute if it were stolen? His Lamborghini, for example.
Yes, Your Honor. I would say in this case, Maxwell Smith had a vast collection of over 200 items, for which he bought the Andre Walensky house to display the Andre Walensky house and the items. An object like a Lamborghini that Mr. Smith may or may not have had would not be one of those objects of cultural heritage as contemplated by Congress in passing the Theft of Major Artwork Act.
I don't understand that at all, because subpart 2 defines, quote, object of cultural heritage as an object that is, B, worth at least $100,000. So if Mr. Smith lives at Galisteo House, he parks his Lamborghini there, and somebody steals it, then why isn't it within this statute?
It's not within this statute in this case, Your Honor, because that would not qualify as one of the objects of cultural heritage contemplated by Maxwell Smith in displaying it in the Galisteo Foundation.
That seems like a very fuzzy test to me. So the only objects of cultural heritage are the ones that inside Mr. Smith's brain he considers to be objects like that, regardless of meeting the statutory definition?
Yes, Your Honor, and here
Yes, you agree, it's just what's in his brain?
It's in his brain, and the record indicates that he had this over 200 item collection that for which he bought this house. The difficulty with the court's drawing bright lines between what is and is not an object of cultural heritage in this case is that art throughout the United States is very different. And Congress had the foresight when it drafted this to say that some items are have cultural heritage value for different reasons.
Mr. Glover, you have no idea how correct you are. As the mother of someone with a master's in art history, there are items that count as art that I wouldn't believe. Twisted fluorescent tubes and large pieces of canvas that are entirely white and other things. So I think it's actually dangerous to move too far beyond this definition that Congress gave us.
Yes, Your Honor, the United States contends that is the case, and Congress's broad protection was for that very reason. The care, custody, or control is attempted, or other courts, other petitioners in other courts attempt to limit the terms care, custody, or control in other criminal contexts. The United States versus King in the 11th Circuit interprets a case involving the federal bank robbery statute. In that case, money is moving from several locations via an armored truck to a bank. Petitioner King steals the money in that case from the armored truck and argues that the protection of the federal bank robbery statute should not apply to him because the money was not in the care, custody, or control of the bank. However, the 11th Circuit does not adopt such a limitation of the term care, custody, or control. Instead, they extend the legal ramifications of the care, custody, or control to the bank as a matter of law, while the custody of the money they explicitly said the custody of the money remained with the armored truck.
So let me ask you then, suppose Mr. Smith had taken the Scrimshaw whale's tooth with him on vacation to Hilton Head, and it's stolen from his hotel room in Hilton Head. Is that a theft of major artwork under the term this statute?
No, Your Honor.
In other words, governed by the 11th Circuit case you just mentioned, because it's usually at Galisteo House. He just happened to like it a lot, took it with him and filled the head.
No, Your Honor, the 11th Circuit's holding was an extension of the interpretation of care, custody, or control.
Well, why isn't the Wales tooth still in the care, custody, and control of Galisteo House, even though Mr. Smith took it with him to Hilton Head?
Well, within the Theft of Major Artwork Act, it's required to, the objects of cultural heritage are required to be within the museum. So Maxwell Smith took the Wales tooth scrimshaw with him on vacation.
It just says from the care, custody, or control of the museum. So if money is in the care, custody, or control of the bank while it's sitting inside the Brinks truck, why is the tooth not similarly in the care, custody, or control of the museum if it's normally in the museum?
Well, Your Honor, I would argue that at that instance, the federal, the Theft of Major Artwork Act would not apply because the scrimshaw has traveled with Mr. Smith to his out-of-state location. However, here, the objects were within the grounds of the Galisteo Foundation inside the Andre Walensky house where Petitioner Brand took them.
If I recall correctly, that the court considered the custody of the van carrying the bank things to be part of the bank custody.
Yes, Your Honor. The care, custody, or control extended to the bank, and the court went beyond just resting with the agency relationship between the armored carrier and the bank.
So it was still part of the bank.
Yes, Your Honor. Yes, Your Honor. And this actually brings me to my second point. The Congress intended broad protection for pieces of major artwork and objects of cultural heritage, not a limited definition of the items within or the requirements within the Theft of Major Artwork Act. Opposing counsel mentions Senator Kennedy's discussion within the legislative record. He goes on to say that this act is an important step toward addressing the serious problem of art theft in the country and punishing those who assault our cultural heritage by depriving us of these great objects. Indeed, he was concerned with the national problem of the theft of major art. And
Do we have any treaties in this area?
Not that I'm aware of, Your Honor. In response to this, Senator Kennedy was seeking to increase the statute of limitations for art theft reporting. He wanted to authorize an FBI investigation for what he truly saw as a national.
Do you agree with counsel for the petitioner that this legislative history did not relate to this specific statute? Is that correct? So what Senator Kennedy was talking about was not this specific statute.
I disagree, Your Honor, because the creation of the Theft of Major Artwork Act started with this legislative record, and this is the legislative history that informs us in our analysis.
Even though at that point he was addressing a different statute.
Yes, Your Honor. Yes, Your Honor. And he goes on to not want to punish only the criminals that were stealing theft of major art from museums, but also to penalize galleries that were displaying objects of stolen art. This is a congressional response to a national problem that Senator Kennedy was doing rationally.
But what if Smith had kept all of his items in this closet, locked it, and told the museum people to stay away? You have a different case.
Your Honor, is the assumption that no individuals visit the Galisteo Foundation any longer?
No, there's
The foundation, they just don't get into the closet.
The difficult there, Your Honor, is that other objects of cultural heritage that are displayed within the Galisteo Foundation would be receiving protection, while this did not. Indeed, Congress.
So in other words, are you making the argument that it's not possible for Mr. Smith to segregate? I take that to be the import of the question.
Yes, Your Honor. I do believe that the Theft of Major Artwork Act does not contemplate segregation of areas within a museum to where federal protection applies to a problem and other areas of a museum, say the hallway, where state theft protection applies. Congress's intent was to protect all objects of cultural heritage located within museums, which is what happened here in the Galisteo.
Doesn't that just reflect what's the problem with the application of this statute in this case? This is his house. Everything in this house is in his house. Now, it happens to also be a museum, but it's not really, these objects have nothing to do with this museum is for. They're just the things in his house, which happen to be of cultural value and heritage. But they're just his thing.
Your Honor, I would agree with you that these are his things in his house. However, this is a unique situation. This is also a museum that was organized in the United States for the purpose of showing the work of Andre Walensky, and personally for Mr. Smith to display these objects of cultural heritage these 200 items in his personal collection. So this is a unique case. Indeed, museums throughout the country are very different. The Frick Collection on the Upper East Side of Manhattan is a home with a gallery in it turned over and created into a museum. Just an hour north, the Storm King Art Center is a 500-acre outdoor sculpture garden. And in Colorado, Mesa Verde National Park is an institute that shows Native American dwellings.
But at least there, the objects are tied into what the purpose of the museum is for. There's a correlation, there's a connection, which isn't true here, correct?
That is correct, Your Honor. However,
there's no integral connection, I think is the word that they used in Pritchard, between these objects and what the museum is about.
That is correct, Your Honor. However, the court also did not foreclose on the possibility that museums not related to the purpose could also not fall under the protection of the Theft of Major Artwork Act. So because these items were under the care, custody, or control of the Galisteo Foundation, and because Congress intended broad protection for pieces of major artwork and objects of cultural heritage, the United States asked this court to affirm the judgment of the 12th Circuit in all respects.
Thank you. You may proceed.
May it please the court, petitioner has one point on rebuttal. Respondent expands the definition of care, custody, and control to any sort of object of cultural heritage located inside a museum. Such an application would lead to the federal criminalization of thefts of any sort of objects above a value of $100,000, including the Mr. Smith's
cultural artifacts.
Not particularly, Your Honor.
That's what we're dealing with here in this case.
And the fact that the statute might have some application that might possibly be unconstitutional, how does that help your client? As applied in your case, is it unconstitutional?
Yes, Your Honor. In this case, it would be, because just like if Mr. Smith had a Lamborghini or an ivory-encrusted toothbrush in his own bathroom that was over the price of $100,000, these objects are indistinguishable from the objects within Mr. Smith's private quarters and the objects available to the public in this foundation.
I don't know who goes around with wall maps of the United States by Osgood Carleton or things from Charles Darwin's Voyage on the Beagle. It seems to me these are objects of high cultural interest, and that even though maybe we wouldn't have the same case for its Lamborghini, this is right in the core of what this statute's about.
Not particularly, Your Honor. Applying the statute in this particular case would expand the meaning of not only care, custody, or control, but an actual museum beyond any meaningful bounds, and therefore would lead to absurd results such as the federal criminalization of any sort of theft of any sort of object from this house that would fall under the definition of an object of cultural heritage.
Isn't the problem really just that this is a dual-purpose house? It's a small museum. It's like the Terror Museum used to be, or it's like other small museums, maybe once the Frick. And one has to think of the museum function separately from the personal function.
Your Honor, I see that my time has expired. May I please answer your question? This is a confusing situation because of Mr. Smith's dual capacities. But particularly for that reason, Mr. Smith could have taken additional care to ensure the protection of his objects under federal statute as opposed to the state statutes of typical theft. Thank you, Your Honor.
Thank you very much, Counsel.